You're thinking about applying for citizenship. Are you eligible 3 years after you get your green card, or do you have to wait for 5 years? I'm attorney Jennifer Bennett. I'm an immigration lawyer here in the Chicagoland area, and I love helping immigrants one visa at a time. I know that it's complicated, and I'm going to explain to you in simple terms how you know if you qualify 3 years versus 5 years after you get your green card. After you have a green card and you want to go on to become a United States citizen, you will file an N-400 application, an application for naturalization. So N-400, naturalization, citizenship. You'll often hear all of these words used interchangeably. They all mean becoming a United States citizen. It's all the same process. Here's the thing though, you have your green card, and your uncle or your niece, when they applied for citizenship, they had to wait 5 years. But your friend who's married to a United States citizen only had to wait for 3 years. Why is that? What's the difference? Let's talk about the 3-year rule first. It's the most simple. If you got your green card through marriage to a United States citizen, or you got your green card through VAWA, which was based on an abusive marriage to a United States citizen, you're going to be eligible to file for citizenship after you've been a permanent resident for 3 years. In fact, you can actually put the application in as early as 90 days before the 3-year mark, but immigration can't approve it until you've been a resident for 3 full years. So let's talk about the specifics. Either, again, you got your green card through VAWA based on marriage to a United States citizen, or if you got your green card through your marriage to your spouse, you still remain married to your spouse and living with them. It's a good, honest, genuine, real marriage. Then we have to show that you did not abandon your residency during the 3 years that you held your green card. So how do we do this? I always explain to clients that there's 2 rules. Number 1, you can't have had any trips of more than 180 days. In other words, 6 months. No trips of more than 6 months outside of the U.S. as a resident. And also, over 1/2 of your total days in the last 3 years need to have been spent in the United States. This will prove that you've been a continuous resident and had enough physical presence in the U.S. to qualify for citizenship. So let's say you're watching this and you've separated and you're in the divorce process, or you've already divorced, or your spouse is no longer a U.S. citizen, then you're not going to qualify based on the 3-year rule. You're going to have to apply based on the 5-year rule. Now let's talk about the 5-year rule. What does it mean? Again, if you're not still married to a U.S. citizen, or you got your green card in any other way, let's say perhaps your employer sponsored you, and you are working as an accountant or an engineer, and you got your green card through the employer, or you got your green card through another family member, such as an uncle or a sibling, then you're going to have to wait to apply for citizenship based on the 5-year rule. That means you're eligible to become a citizen 5 years after you became a resident and got your green card. Again, you can apply as early as 90 days before the 5-year mark, but immigration can't approve your citizenship application until you've been a resident for 5 full years. Here's one thing I see go wrong a lot. People are confused between the 3-year and the 5-year rule, and they apply too early. That means they waste time and effort preparing the application, and even worse, they waste money because immigration will not refund the filing fees. They'll just deny your application. The second thing I see go wrong is someone leaving the U.S. or being outside of the U.S. for too long. It breaks their continuous residence or their physical presence, so they no longer qualify for citizenship. The third thing I see go wrong is that a client will make the wrong assumption and assume that just because they got their green card through marriage, even though they're now divorced, they think they still qualify based on the 3-year rule, and that's not true. They need to wait for 5 years. So if you're still confused after all of this, it makes sense. I'm an immigration attorney, and I have been for over 15 years. It's confusing, but trust me, I know how to help you figure it out. If you're getting close to your 3 or 5-year mark since you got your green card, it's a great time to call our office so we can talk about starting the process. I'm Jennifer Bennett, an experienced immigration attorney who's been helping immigrants for over 15 years. I love helping immigrants one visa at a time.